the first to know Nsem-Pii TV.
Okay, for your lawyer be and any aiding commona, a acting Chief Justice Baffo Bonie, just say, and this is for seeing sworn in, now you're sworn in as a Chief Justice of Ghana. Now, lawyer each say, a Chief Justice, penny fairten, I see any Nsem-Pii or Kayano, not a camera where say, Baffo Bonie, or active beyond the law, and just say Baffo Bonie no. Onye sanye emrano ekano sa kabimamenke bi amumu no enye eno ona womudi adwuma sanye President John Dramani Mahama one ne nkrofo eye ne omope na womu endi emrano ekwan so na je se yehwe kwan afa so yiye mame eye getutoko no empu elisi nchen a na entwayi na lawyer yi ensemode atudwa no Nsem-Pii
Akoba say mami ya the Chief Justice we yaba. Now say Chief Justice or no acting Chief Justice or can Nsem-Pii kra na no de. Also no sentence atai di no sentence wa na chese we o ya ma atai kra no. Wasan ko di be.
Hono meba because hono na me bo video no kra ba. Ahwefo eti me sheda aba ho de
no. Before ansa na obetimi aye Chief Justice na na so be judge no osue oath na oath na osue ne say what the mara no ene pepepe ye ene de be ye obia e mara ne sesen so obi am robber charge say nko na de charge na into oko 71. I'm not saying say atayi eye bone a nipa okunkum omo ne ade e o se eja no e ma ne ko, but the point is saying mara ne sia prescribe say o so de punish no eti wo hwe say wo no o so no they are prescribed one man on a no neto da ohwe let us say otu na oso ye no enya no na acting Chief Justice no dey adwuma
Chief Justice na
no so enya stated misbehavior ni bia you see stated misbehavior no enya bia you see question me bisa ne say atimi de stated misbehavior bia ade ne nya stated the kra na wo ho because makasa article 1911 of the 1992 Constitution of the Republic of Ghana any offense bia yen state ye bia no untimi mfa punish obi eti before I become stated misbehavior no that be I can say them adjective word stated no and I qualify now misbehavior, therefore adjective qualifies now and adjective no abe qualify now misbehavior. It is a misbehavior edia na some misbehavior no it must be stated in our written laws. In the written law ben ya state as a Chief Justice o tu kwan and now the be tu kwan in which laws of Ghana and I actually mu. Eti who clear say yetimi the idea where is stated misbehavior near the Chief Justice free wabra stated in the instance because framers of the 1992 Constitution no sebe omo nya obi omo da omo nwino omo dwenem yie pa anti no omo dey stated be kan misbehavior ho sa se mekeke meka da bia enti before misbehavior bi be misbehavior na chese sa offense no must be stated that was say actual e were written lawsuit what and on Article 1911 of the 1992 Constitution of the Republic of Ghana, so all offense must be stated and the penalty for it must be prescribed in our written laws. It is a state offense na offense. Now that this offense ni bebo bi na di remove no as Chief Justice. Now so what's your oath as a Chief Justice? As a judge, I would asem say oath no. What the almighty mra na ka pepepe na de be ya adwuma na tentrene na de be ya adwuma when this tentrene kire say obi a armed robber na first count ya robbery maximum ya 25 years robbery no maximum aye do watum a chekora no 25 years edin fan so commit robbery ne be 10 a o kan 25 years the time say 10 a obetimanya maximum all things being equal me mfa ne say maximum no na wo de bono. It is a maximum sentence crana the 25 years no kwatam setan ya man 71 minimum charges do I the born there ya man 71 years so one kasa one punishing we are wasan begina as a otu na so ya na nya no na ade ye adwuma nemum wo de de na wa wo pe na ye adwuma etianya me nwanwa say sa Chief Justice we acting Chief Justice wo san de ne be ye Chief Justice a de open no de be ye adwuma na so eti de open no de be ye adwuma de a ono amount so anything be obetima create misbehavior no the amount stated misbehavior near the remove What you say? Because
Nana Kwame, yes, and one I was speaking to, but Nana Kwame, where they met Wadaruma, Master's video, the Calbesa to be the
3 years. We sit in Accra here. When a magistrate at Gosu decides to send the boy to prison for 3 years, we sit in Accra here and say the man stole only a bunch of plantains. Do you know what it means to what the bunch of plantains means to my mother? It's like stealing your car. You see, so I mean there are so many reasons. The magistrates and the judge, they are trained. They have this. The sentencing guidelines. They have them, but sometimes they have to go beyond it. In my youthful days, I gave somebody 70 years. Atayi, I gave him 70 years. And what I told myself was that if Atayi was given 30 years and he comes back, my family will be the first family he will attack. So by the time he comes back after 70 years, I'll be dead and gone. We sit in Accra here.
And gone. But lawyer, the key word, or say he has to go beyond. Beyond.
Yeah.
Now, just also say or just then kwa ehiano.
Yeah.
What do you say?
Yeah.
Then kwa ehiano. Jolly we are not just omrana.
Yes.
Where we call the kwai.
You see, or can be as a Ghana, your judges are being trained. You train you on your sentencing guidelines. Asama obiena no kano. You see, Ghana does not have a single codified sentencing guidelines document. You need single codified sentencing guideline. But ye didn't be a free a criminal code dominate criminal procedure when it comes to criminal issues. And other laws are be say mining laws. A been a dynamic regulation 33 to regulation 43. No, it places much burden on ya manager. Wo mining sites and say now here's environmental problem hazards ni bibia be protect environment. And yet the leaseholder yamani to mean say ebia chama wuntumi on the lease in the man but wo manager no ebi ni manager no mo ba be use no de na be ye accuser or ba be ye witness no. So the point is, whilst a Ghana ni sentencing guidelines a codified one ya codify ni nyina other jurisdiction no oko United States ni other UK umbetime nya sentencing guidelines ya try say by the ne e define to beba mining law u breaching mining regulation na e won sentencing guidelines ho sa na oye boni bia ya criminal code no na we say ya dey sentencing guideline and looking at the severity of the offense na wa commit no ana a prescribable punishment for it. And America say if you read article 1911, actually say all offenses must be defined and the penalty for it must be prescribed in our written laws. And this offense be you define it. Now penalty for it no has also been prescribed in our written laws. So there. Then the sentencing guideline no ya the amount dada. I wo emuse uhunu say sentencing guideline no e wo ha say nipa wo ye boni we ya asotwen say ne de ma no. So the point is, and then also who go beyond. It is all person who change who go beyond the sentencing guidelines. And to be candid with you, sentencing guideline for armed robbery or armed robber. And I make a choice. There is no judge in this country who can boldly say the sentencing guidelines in respect of robbery ever caught more than 25 years, the maximum. And it means that the person had a brush with the law. That means that person had already committed series of offenses, and the person has been pronounced guilty by a court of law, a competent court of law. So the person had a brush with the law. It means that the court to be a punishes any panel with the same punishment, and then I'll be in the court 25 years. It is a you committee offense. No offense.
That is way 70 years. Do you know?
71. Go beyond the sentencing guideline. That is the true picture or the true nature of the acting chief justice that we are dealing with. And then I make what I say. I have Quran never said chief justice. You intimidate na so near position. If in some because if the rules have prescribed what? A mode that was all the punishing will be. You don't go beyond it. We all are servants of the rules and we need to worship the rules. And the rules are not ornamental pieces to be broken. The rules are not ornamental pots to be broken. It is Ghana, you prescribed. If you read Boifie versus NTAC Properties Limited, it says that where a court prescribes where an enactment prescribes a procedure, that procedure ought to be followed. So enactment be actually procedure be say procedure way and yemfa emu mind procedure way yemfa punish obia. You cannot go beyond it. That is why I'm saying that Boifie versus NTAC Properties Limited. I think 1998, 1999. One Ghana law report, I think, I stand to be corrected. It says that where an enactment has prescribed a procedure to be followed, that procedure ought to be followed. So it means that say enactment be rules be actually kwanya yemfa so mfanye bibia. Untimi mfiri, you cannot go beyond it. So if you look at the acting chief justice, the statement or kana, actually say or sentence wa onko otu na waswe no. Ese media maswe otu say me acting chief justice.
I say or did the bush here for life is in danger.
You see if you read article 296 of the 1992 Constitution of the Republic of Ghana, it says that whoever wills power, and answer obi a de power amani biano, that person should be fair and candid to everyone. Any kwasa power na e de amount no, you no capricious. Any kwasa we use no resentment. Any kwasa we use no what? Arbitrarily. Enti sa west we article 296, you should be fair and candid to everyone. So obi aye bone rules na prescribe say na was punishment. What go beyond it? Also abegina swear oath of allegiance and answer oath. Actually say Ghana for me the pepepe ye any omeyimbra and ebeye ebedi obi a pepepe. Now Chief Justice is saying this in the presence of the learned people our parliament. Now obi raise objection to that. No actually say disputed Chief Justice Mama Yariga Jina Hose say ni panintimi nkasa sa asem no. You see some of us here to abamaye. Emayen parliament and that day parliament won komu ni asem no. I'm telling you kayen hwe no. Because some of us can be very rude parliament wo. So parliamentary hazards na any bibia ekoso bi anka nya adwuma no manya record. The point is that
parliament will need rules.
Oh, the rules. You see, but rules no. You will rules near practice. You see, e bi na me catch us so you su co-accused person. E de na be ya witness. There is no rule. Ghana, say accused person, co-accused person can be used as a witness. There is no rule. But oba per practice, lawyers and judges, manakoso. And there is a decided cases yebenya. But rules no so per practice, ora afenyo markings, right say we make commentary. Per practice started war about a yimu nyina so Peter Lajete no mo war parliament nyina. Eti per practice na de bia e hawo no. E was say oventina sa de ni free mu. Eti oka sa de na wo say o the rules o ba be ya adwuma nti practice na nya adwuma. Adenti na e war practice direction. Chief Justice between the practice direction about say efunu bia wo wu ayemfa injunction to so within 14 aye ne ba be yemfa injunction to efunu so. And so be aye boni ani funu na wo say the injunction so about practice direction nya ba untimi nya hwemfa. Enti na me kire say if you look at the demeanor, the conduct and the Chief Justice ne someone wo kan enya me nwanwa so mo remove Mami Esaba Araba Tokono. Because the rule says that a stated misbehavior, and the word stated is an adjective word qualifying and now misbehavior. It means that misbehavior to me so this unless the offense is what defined, stated. So framers of the 1992 Constitution, and answer for let us attach an adjective word to the misbehavior so that it will make the misbehavior to be strong. It means that every misbehavior must be stated in our written laws, which is in tandem with Article 1911 of the 1992 Constitution of the Republic of Ghana. All offenses must be defined and the penalty for it must be prescribed in our written laws. Ehene fa book muni actually say Chief Justice timene na yere ne ba into kwan. But you use way as misbehavior they true no dia. Aden na acting Chief Justice no. Ono de was sentenced to obi abro so abra was swear oath of allegiance and misbehavior for him to be removed. And the point is that say ya anya careful now swear ni in we are decision a Ghana Bar Association versus Attorney General. A Supreme Court decision. Ghana Bar Association versus Attorney General. You cannot, maybe say and I to Abama MPP Cromon to me remove sa Chief Justice no unless offer Article 146 no so. And Mammy Tokuno si any ye. Et Mammy Tokuno teho. Our no sunim so no. And the Nanko your Chief Justice oba. You used to Article 146. I know what challenge so we a disputed Chief Justice because what challenge wo opposition now over say wo what challenge into the matter is before a court of law. It before a court of law, I don't want two school of thought. The moment I walk court of law, you can say a swear in. And your markings are some can say disputed acting Chief Justice. Oh, you're right. Because say pan one kasa office now ban a disputed I walk court. And two, ye jaw near swear winner. One now be panel. Sir judges 5 and a 3 and one near then 5 no more matter so. A better than my in a fair trial. So be who the entire Uber rules are a government parliament as a uni home so I can say that we have rules. There is a clear dichotomy between what rules and what and practice direction. And per practice the a parliament here. It would mean per practice so by your school now Roman for you the ABM the Yasamka or when you ask Talisi or Monase. Ghana Lobia and Chester by per practice Roman sorry be on the Omas Atarisi or Monase. So practice is different from the rules. The patron when you mention. So I guess I do I tell you chromophobia and one median home because of it me attack me. But the point is I know interest also go beyond sentencing guideline I the amount. Sentencing guideline also on one case or no men.
If I'm not mistaken, Bayer 7 legal suits also in the court regarding so. A Chief Justice. That is so. Now, Yavete a year Justice Paul Baffo Bonie. Nesi so do ba be Chief Justice no. Sadi uchire mu no. Na che so do no ba be hwe a year ma be do asem no so. Na ono aba betina akoya no hu no say enya ade obehwe say
ma me nya fair trial. Aha no nya fair trial. And if you look at the
and obi can say bi amo na mo bro for preempt and
no, that we are not preempting any court or prejudicing the mind of the omo no ye no, rather prejudicing the mind of the court. Because what the national so we enti ma me na kora wa asem na court nsa ama na ye mut. Because I'm challenging the capacity of the acting Chief Justice. Yeah, the neighbor be Chief Justice. And the matter is before a court of law. What court of law yedi. And I will walk in because President Mahama pentem bibia fast. Omu hasty madam for being a kind. I don't know what they are rushing for. Within 4 years here was here to me a reset her. Within 4 years Ghana School of Law I was here resetting and crop on kwa it me gulamu more. So be at 3,000. I was here for you making sure NDC for ABA lawyers. You see the point. At the end I will rush do a minor cause. So the point is Ghana Bar Association versus Attorney General. Supreme Court dikara kasa asem say Senya so obi mane be Chief Justice untimi remove no be president be ntimi nsake no because if you read the case of Agbebo versus Attorney General when President Kufuor sought to remove Agbebo as a judicial secretary President Kufuor yes obey Agbebo a free ordinary to me as a president of the republic Agbebo court sexual right to quash what the president is doing so president need power say witimi then e ho na na hu through democracy so we need to mean say sack me because the onus lies on the Chief Justice to sack me, but not you. Power near the Chief Justice on me free so as a judicial secretary, but not you, the president. And the court, indeed, court catches a President Kufuor with the whole kind. And the court put fetters on President Kufuor's functions now or person. That's a clear separation of powers here, a clear democracy. But the point is, wait there. One kasa acting Chief Justice obey Chief Justice o na obey panel nipa amoma betna maame isaba tokono asem so and what challenges say wo kra de do tena so me kwan mo fa so yi mi gusu ye Chief Justice kra me kwan mo fa so yi mente ase court no mfa ne decision mra nanka o de mane ate kopim say ye benya Chief Justice amana betna ho okay ni enya obi oye obey fe say wo de na betna so ufi say ba bia de na betna nti obefiri ho ama obi aba free one mame isaba tokono ensamba. But you see, the American said the way ni nebiano. Let me tell you, kwan o mafa so yi mame isaba tokono. Menye panyin wo MPP but what I'm telling them ne say, a 1,000 years cry this woman will be reinstated. Omo instating no krombe tue ni sika nyina de ama no matter law bi a NDC beses ane bia. Mame ni sika no obo ano de ato. And me, I'm not minya power. There's a KBA president, Dr. Baumia, now say, Iraq and the Japan, now more pre-B, Benya Post, Yama, me to me, say, Kwasha Honoma. I can't remember what you see, Nadia Mano. No, Mamma Gana compensating my menocra. because kwa mu fa so yi no emre bi anim. The point is papa yi wo de na ba o se oye acting keke o acting na na wo de na betena so enipa ye challenge na work court of law ayedi ono so na ebe empanel judges amoma betena na sense na he fa na obenya pepepe ye if you read the